Good afternoon. My name's Marjorie Pearce, and I'm at Ballard Spahr Stillman Friedman. I'm going to here to talk to you about ethics. You've had a lot of great training here for the last 2 days, and I'm going to kind of now talk to you about some of your ethical responsibilities and how they may crop up in connection with Clemency Project 2014. I'm going to be flagging some issues for you. I'm going to be issue spotting for you. These are general guidelines about your ethical rules. I'm not giving you ethics advice. I'm giving you a roadmap of the things to look for as you embark on this project. The rules I'm going to be talking about are the model rules of professional responsibility, model rules of professional conduct. Each state has different rules. Each state has adopted different provisions. And so what you should be doing is checking the rules of your own state as you embark on these projects. So the first thing I want to talk to you are about the general ethical guidelines specific to clemency representations. The first thing you should be looking for is, does a conflict of interest disqualify me or my office from the representation? And I'll go through a couple of those potential conflicts as I go through this presentation. Second thing you need to make sure is, does the client understand my role in evaluating whether he or she meets the criteria for clemency, and my role in preparing a petition if he or she does. And here we've got form limited representation agreements and consent forms, which will be available on the website for you to sign with your client. Again, you need to check the rules of your own state in terms of whether there are additional provisions that need to be in those agreements. Third thing you need to talk about and think about is, have I considered potential adverse consequences for the client in current or future litigation? And these are the sorts of things that were addressed earlier today: habeas corpus petitions, quorum nobis petitions, ineffective assistance of counsel claims. And so you need to be very conscious of that as you are considering your petition. And the final thing, of course, is, have you obtained all necessary consents from the client? So there was a question actually earlier yesterday about whether their limited representation does constitute an attorney-client privilege, and yes, it does. And so that's why you want to make sure you have an executed limited representation agreement. If, in the end of this process, your client is not going to be accepted by Clemency Project 2014 for the submission of a petition, and you and the client wish to proceed nonetheless, you're certainly entitled to do so. You should execute a separate representation agreement for that client to go forward independently. So, what are the goals? Your goals are to protect the clemency client, protect your duties to other current or former clients, and of course at all times perform your duties ethically. Again, as I said earlier, this guide is based upon the ABA rules of conduct, so you have to check your own state's rules. So what this guide is going to do is going to help you navigate potential conflicts of interest. It's going to help you address imputed conflicts of interests and what you should do if one of those conflicts arises. So first, let's talk about the ABA Rule 1.7, which addresses conflict with concurrent clients. And that rule states, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. It goes on and talks about if there is a direct adversity or significant risk that the representation of one or more clients will be materially limited. It's here on the slide, as you can see. So, going to each state being different, New York, where I practice principally, only deals with differing interests or a lawyer's personal interests. It doesn't deal with former clients or third persons. Former clients are addressed by Rule 1.9. So again, look at your own state, but you need to see if you represent somebody now that could be at conflict with your clemency client. You need to examine whether you can proceed with that representation. Now, there is a caveat in the conflict rule for 1.7, and there are 4 prongs that you need to make sure that you can meet. That is, if you believe you can provide competent advice, it's not prohibited by law, it's not a claim of one client against another in the same litigation, and each affected client gives informed consent in writing. And that's going to be critical because some of these people are going to be in jail. And getting the ability to give informed consent and the ability to get that consent in writing will be very difficult. And under those circumstances, you should consider returning to CP Clemency Project 2014 and asking that this client be reassigned rather than taking on this risk of having an insurmountable conflict. So now let's talk about ABA Model Rule 1.9, which addresses conflicts with former clients. And under 1.9, you cannot represent somebody if there's a substantially related matter and where the interests are materially adverse. I'm cutting through the language here, but it's the substantial relationship and material adversity. If you have such a situation, if the former client, again, gives informed consent in writing, then you could proceed. So this raises, once again, making sure that you get that informed consent in writing, which again may be very difficult because of the incarceration issue. So this is another circumstance where if you are presented with such an issue, you might want to return the case to Clemency Project 2014. I should be clear here, I'm talking about the pro bono lawyers. Defenders will have different issues and they'll be addressed by defenders. So here I'm talking about pro bono lawyers in Clemency Project 2014. Now, also with respect to former clients, even if you can overcome your ability to represent the person, you can't use material adverse to the former client and reveal information about the former client. So that's another reason why you might want to seriously consider not taking on a former client, a matter where you could affect a former client. So, as I say here, ultimately your representation might not be advisable, and as I've said earlier, the written consent may be difficult to obtain. You also need to consider whether your personal interests might preclude a representation. So, one of the things to think about, if you're now being asked to represent the same person, a client that you previously represented, did you make a mistake in the underlying case? Did the client assert an ineffective assistance of counsel claim against you? Did somebody else raise that you made a mistake? Can you, if there had been such issues raised, can you nonetheless proceed with the clemency case? I would suggest that if such circumstances arise, you would be best suited to ask Clemency Project 2014 to assign another lawyer to the case so you can make sure your current client gets the best representation. So, when do you look for conflicts? If you get appointed to represent somebody in Clemency Project 2014, you'll be involved in evaluating that client's potential claim. And if you and the screening committee conclude that the case meets the criteria for Clemency Project 2014, you'll be involved in preparing the petition. These rules that I've just discussed, 1.7 and 1.9, apply to both circumstances, and both of them constitute the representation of somebody and create the attorney-client privilege. So let me give you an example. Say you represented a co-defendant formally of your clemency client. One of your arguments for clemency would be that there was a disparity in sentencing between the clemency client and your former client. Perhaps you will need to argue that your current client was less violent than your former client, or was a lower level participant in the scheme. Obviously, to make this pitch, you will need to be arguing that your former client was more culpable than your current clemency client. You'll need to be disparaging your former client. This would create a conflict between your duties to the clemency petitioner and your duties to the former client. Under such circumstances, it would be advisable to decline the representation and ask that somebody else be appointed. Another area where you might have a conflict is if you are using information from your former client in order to help your current client, and it would be to your former client's disadvantage. So, say you learned from your former client that threats had been used in some way to get your current client involved or to implicate your current client more. If you were to use that information on behalf of your current client, you'd be harming your former client. And if that former client came forward with a clemency petition, information that you disclosed could be harmful to your former client. This is another situation where I would suggest that you should turn down the representation. So, in general, if you've had a prior relationship with somebody who is involved in the overall scheme with your current clemency client, you really need to think long and hard, examine your rules, examine the facts, examine the law in your state to determine whether you can take this on, but more importantly, whether you should take it on. Is it fair to both clients? So now let's talk about imputed conflicts. Imputed conflicts come up in both ABA Model Rule 1.10 and 1.11. 1.10 applies to lawyers and law firms. 1.11 applies when former government lawyers come into law firms. The general rule is that attorneys working in the same office or firm are prohibited from representing any client. If they had been solo practitioners, they would have been precluded from the representation. So that should be your test. There are exceptions to the imputed conflict rule if it's based upon the personal interest of the disqualified lawyer and does not present a significant risk of materially limiting the representation, or the prohibition is based upon a former involvement with a law firm that represented the materially adverse client. In this circumstance, the rule requires that an ethical or screening wall be implemented, and that notice be given to the former client. I hate to sound like a broken record, but you need your own state's rules. So for instance, in New York, our model rules don't provide for an ethical wall under these circumstances. Case law does, so you need to check each state's rules before you decide that you could proceed. Now, with respect to government lawyers, assume a former federal prosecutor who was in an office that prosecuted your client has joined your law firm. You would need to know whether that prosecutor was substantially involved in the prosecution of your client. If they were, then they would be precluded from participating in the representation, and you'd have to set up an ethical wall or screening procedures. So, again, you need to understand the underlying facts with respect to the representation. Now, in practice, implying ethical walls in a situation is an unlikely remedy or effective remedy in the clemency context. Again, as I had earlier with Rules 1.7 and 1.9, obtaining your former client's consent or the client's consent will be difficult. So you should just, this may be another circumstance where if you are having difficulty doing so, you might want to consider asking that the case be assigned to somebody else. So I've given this example of the Assistant U.S. Attorney, so this is in the materials if you want to just be reminded of it. Now let's talk about informing the client of your role in the representation. Under ABA Model Rule 2.3, when a lawyer is conducting an evaluation for a client that will be reviewed by a third party, and when the lawyer knows or reasonably should know that the evaluation is likely to affect the client's interests materially and adversely, the lawyer shall not provide the evaluation unless the client gives informed consent. So let's break that down. Here, you're going to be doing an evaluation to determine whether you think that a petition should be filed on behalf of a client. You're going to then turn that evaluation over to a screening committee, that is a third party, for the screening committee to ascertain whether it agrees that a petition should be filed, or you may conclude that a petition shouldn't be filed. So certainly, under Rule 2.3b, if you were going to provide an evaluation that a petition shouldn't be filed, you would have to have client's consent. We are advising here, and the form documents that we have provide for upfront acknowledgement and agreement by the client for you to be able to provide your evaluation to the screening committee. We're not advising that you wait until you reach the end of your evaluation and then get the client consent. Our advice is, and the forms you will see on the website are getting that client consent right at the beginning. So, your ethics rules may not require it, although I would take the position that the screening committee is a third party that you would need consent for anyway. But to just be really safe here, this is our suggestion, and that's what the documentation provides. A question was asked yesterday about what to do if the client won't give that consent. If the client at the beginning says, I'm not going to let you give a negative evaluation to the screening committee, our suggestion to you here is come back to CP 2014, ask CP 2014 what to do in this circumstance. You're going to be spending a lot of hours doing an evaluation, and if the client is saying to you, if it's going to be a negative evaluation, you can't turn it over, you're going to need to think about whether this is the case that you want to be doing the work on. Maybe somebody has a prior relationship with the client and can talk to the client, but I strongly urge getting that consent at the beginning. So, to be clear, evaluation is a representation because you are making determinations and recommendations, and your representation starts at the evaluation stage. So let's set expectations. To avoid running afoul of 2.3, make your role clear at the beginning, obtain consent, and remember that your recommendation will determine whether the petitioner will have an attorney appointed. And if, as I said earlier, if the screening committee or you have concluded that a petition shouldn't be filed because it's not consistent with the criteria that's been set out, there's nothing to preclude this client from filing a petition away from CP 2014, and there's nothing to preclude you from doing that. Get a separate representation agreement. So now I want to talk about a couple of different examples. And this one is a little bit absurd in terms of the example, but you're going to have a lot of absurd things coming your way in the course of this project. So Courtney is a prospective clemency petitioner. She served 10 years of a 14-year sentence for possession with intent to distribute tar heroin. Her sentence was high because she had a criminal history category 6, which was the result of an untreated heroin addiction. And as you've learned earlier, you're going to learn all these sorts of facts about your client from the pre-sentence report and other documentation. So assume that you're able to ferret all of that out from the documentation you reviewed. So far, this looks like it's a good case for clemency. But while you're screening, you learn that she killed somebody in prison and was never prosecuted for it. This is why I say it's a little bit of an absurd result, but you could have some violence or something that happened in prison. So as the screening attorney, you realize that due to her violent behavior, she's not a good candidate. So you plan to recommend to the project that she not be accepted into it. And under Model Rule 2.3, you would be necessary to get her consent, and this is why you need to do it up front. Mark talked quite a bit about unintended negative consequences with things such as habeas corpus petitions, quorum nobis petitions, ineffective assistance of counsel, and under question 5, the client must disclose a personal statement. You obviously have an ethical duty not to hurt the client. Obviously, you have to tell the truth. The client has to tell the truth, but you need to take all appropriate steps to avoid hurting the client in current or future litigation that the client may wish to pursue. So, keep your mouth shut to the extent that you can ethically and the client can truthfully. So, it's really critical that you need to think about future litigation. So let's talk about Fred. He has a good case for clemency. He served 10 years of his 12-year sentence for drug trafficking. He has an excellent behavioral record, and good family connections. When reviewing the file and completing your initial review, you note that there was a plea agreement offered by the government for significantly less time than Fred actually received. When you ask Fred why he turned down the offer, he tells you he never knew about it. This is a potential claim for ineffective assistance of counsel. It's also something you might want to consider in your clemency petition, because in 2012, the United States Supreme Court, in two cases, Lafleur and Fry, said that individuals are entitled to effective assistance of counsel at all stages of a case, including the plea stage. For those of you that don't do a lot of criminal work or any criminal work, you should know that 97% of the criminal cases in the United States end up in guilty pleas. And so if somebody was given ineffective assistance of counsel at the time of the plea stage, they were either not told about a favorable plea offer or they were given bad advice, you might be able to craft an argument that their sentence would have been different had the Lafleur and Fry been the law at the time. So not only might this be relevant to a potential ineffective assistance of counsel claim or quorum nobis petition, it might be something you could consider in preparing your initial review and then the clemency petition. It's part of your role as a clemency attorney to try to anticipate any future litigation and avoid potential pitfalls to the extent possible, but as Mark said repeatedly, always honestly. So in conclusion, I want to say, remember the rules of ethics are there and must be followed at all times. If you have a question that has not been addressed or that you don't understand that I've addressed today or that is in the materials, you should call the Ethics Committee with the Clemency Project for assistance. And I understand that there's been a couple of questions asked of the Clemency Project as to whether the Clemency Project covers any malpractice claims. It does not. So you should make sure to check your own policies before proceeding in this project. Thank you very much.